So now let's talk for a bit about the idea of a legislative veto. So recall that bicameralism and presentment say that the Congress and the Senate agree on the text of the legislation, they present it to the executive, and it is the president who has the ability to veto or sign into law what Congress has presented. But what if Congress retains some authority to look at the way in which the executive branch might be administering the statute, and then to take further action nullifying what the executive branch is doing or what other parts of the government is doing when the statute is being administered? And you can characterize that in a sense as a legislative veto. The legislature has created the statute and now is retaining some authority to nullify something the executive branch is doing under the statute. And that issue came up in INS v. Chadha in 1983. So this is an immigration statute. Immigration has been fraught as a policy matter for decades. Obviously, it is very fraught and very hot and important in our constitutional and policy discussions now, but it has been for a long time. So this particular statute allowed one House of Congress, any one House of Congress, by a resolution to invalidate a decision of the executive branch to suspend the deportation of a deportable alien. What the statute had done was said there are these classes of aliens in the United States who are deportable, but there may be reasons why the executive branch, in looking at some particular person, might say, even though this person is deportable, they've overstayed their visa, there's some other issue, we're going to suspend that deportation because we think this person or this class of people is useful to still have in the United States. So think of certain kinds of technology workers, academics, other things like that, where the executive branch administering the immigration law might decide to keep someone in the United States. And Congress wanted to retain the ability through any one House of Congress to step in and say, well, we don't like what the executive has done in this case. We think this person should be deported. In this particular case, this person Chadha's deportation had been suspended by the Attorney General, and the House of Representatives passed a resolution under this statute invalidating the suspension. So the House didn't like the fact that the executive branch, the Attorney General, wanted to keep this person in the country, and the House passed a resolution saying this person should be removed from the country. And this resolution under this statute is not submitted to the Senate, so it's not agreed to by the Senate, and it's not signed into law by the President. It's not in itself a statute, it's a resolution. So the issue is, does Congress constitutionally have the authority to do this, given that the statute allowed Congress to do it? The majority of the court, in an opinion by Justice Burger, said no, Congress does not. This would violate bicameralism and presentment. Even though this seems like an efficient way to do this, it seems less efficient for Congress to have to pass a special bill to kind of amend the immigration law and have Senate agree to it, have the President sign it, which may in fact not happen. Burger notes, by design, this process is meant to gum things up. It's meant to slow things down. Legislation is not supposed to be easy to pass. The checks and balances are that you might not get the House to agree and the Senate to agree. You might not get the executive to agree. It's a conservative in sort of the small c, not ideological sense of wanting legislation to have to go through difficult hoops to pass. And Burger said this kind of legislative act, the Constitution requires bicameralism and presentment, which were not present here. Now, one of the arguments made on behalf of the House's action in this case was that this really wasn't a legislative action. It's a resolution. It's a different kind of action. And Burger rejected that and said, no, we're going to look at the action to decide, even if it's characterized as a resolution and not as legislation, is it really legislative in character and effect? And here he said it was, because it affects people's legal rights and duties. Now, there's a concurrence in the case from Justice Powell, and Justice Powell has a kind of interesting take on the case and said that really it wasn't a legislative act. What it really was a kind of judicial act. So the House was actually looking at a specific case or controversy involving the claim of this particular person to be able to stay in the United States, and that really is a action for the judiciary. So for Powell, that is why this violated the separation of powers. Justice White issues a dissent in the case, and what he says is this is a really broad decision, and there are lots and lots of statutes that have been designed with these kinds of legislative veto provisions in all sorts of different areas of law. And it had been sort of a presumption or a feature of legislative design to include these kinds of provisions. And effectively, Chadha is going to require all of those statutes to be revisited. And he suggests that it really is going to make things difficult for Congress. It's actually going to kind of paradoxically result in the further growth of the administrative state, because these kinds of functions of building in some kind of quasi-adjudicatory or adjudicatory safeguard is going to have to be put in the administrative agency. His opinion didn't win the day, but it does sort of highlight the difficulty in regulatory design within the framework of a constitution created well before there was anything like the modern administrative state. All right, let's talk about the possibility of a federal line item veto. There's been much discussion, or there had been much discussion in Congress in the 90s about the possibility of creating line item vetoes. As noted, many states have line item vetoes, and the notion was you're getting these big budget appropriation bills, and those budget appropriation bills have to be enacted at some point for the government to function. And you see kind of almost every year nowadays that the budget is in danger of not being approved, and in recent history has not been approved, and the government has to shut down. And part of that is it's one big bill, and the Senate and House have to agree to it, and the executive has to sign the whole thing. The executive cannot, after this decision, which we'll discuss, can't line pieces of it out. So that has been kind of recognized as a possible problem, and Congress did in fact pass a statute in 1996 saying that the executive could, the president could exercise line item veto power over certain kinds of legislation. And in this particular case, the bill that President Clinton had exercised his line item veto was a budget provision that gave some special treatment to New York. So you could view this as kind of the classic bit of local pork that a congressperson would want to put in for their own state or for their own district. So President Clinton had lined this piece out, and the court, in an opinion by Justice Stevens, said that was unconstitutional. There is no provision in the federal constitution for a presidential line item veto. And effectively, Stevens said the line item veto would allow the president to amend acts of Congress, and that is not how the legislative design of the Constitution works. The veto power, Stevens said, relates to the entire bill. The president signs the entire bill into law or vetoes it and sends the entire bill back to Congress, at which point Congress can decide what to do. The president can veto it and say, these are the provisions I don't like. I will sign it if it's changed in this way, and Congress can decide whether or not to change it. Stevens notes that if we do want to have a line item veto for the president, the way to provide for that would be to amend the Constitution and to provide for it. And incidentally, it's in those states where there is a line item veto, the state constitution directly provides for it. So Justice Kennedy concurs in the opinion and just kind of notes that really what the problem is, if there's a problem, is political, that if Congress can't sort of stand up to those kinds of pork measures, then that's a political problem, and you can't solve that problem by an unconstitutional remedy, which in his view the line item veto was. And there's a dissent from Justice Breyer with O'Connor and Scalia, And they suggest that, Breyer suggests, the line item veto is really analogous to a delegation of executive rulemaking. After all, it is Congress, the House and the Senate, that created the law that allows for the line item veto. And the president signed that law into law. So in the view of the dissenters, bicameralism and presentment was satisfied. It was satisfied when the original line item veto statute was created, and it delegates certain ability to the president to make some changes in the law. That view didn't carry the day, obviously, since it's the dissent, but you can see kind of this interesting dynamic in play in many of these decisions about bicameralism and presentment. Congress has already done something and satisfied bicameralism and presentment. In the view of the majorities in these cases, what Congress did really violated the structure of the Constitution. In the view of the dissenters, it didn't.